Hello, this is Linda Amato from Amato Law. My firm is located in New York City. We are solely devoted to the practice of estate planning and elder law. We are creating a series of videos to help you and your loved ones understand the importance of creating and having an estate plan. Estate planning is the process of arranging to make sure that your assets are preserved and protected during your lifetime in the event of a disability, and also it covers the topic of legacy. How would you like to pass on your assets upon your passing? There's a lot of myths regarding who needs an estate plan. And I'd like to start out by explaining that estate planning really has nothing to do with the value or the size of your estate. Everybody needs to have some really basic fundamental documents in place, regardless of whether you're wealthy, you're middle class, or you really don't have very much money that you think would be at risk. Everybody needs to have a healthcare proxy. A healthcare proxy is a way of you identifying one person or a group of people that can step into your shoes and make decisions on your behalf if you're unable to really participate in that decision because you're ill. It doesn't have anything really to do with end-of-life decisions. That's a separate document. So you need to have a healthcare proxy, and then you should have what's called an advance directive, or it's commonly known as a living will. What is that? All right, a living will is really giving direction to your loved ones what your wishes would be in the event that you're in a terminal state where there's really no anticipation of recovery. Some people have very strong feelings about extending their life if they are in that terminal state. So an advance directive or a living will is going to ask questions. It's going to ask you, if you're in that state, would you want to have cardiac resuscitation? Would you want to be on a ventilator? Would you want tube feeding? Do you want antibiotics? Do you want hydration? Do you want maximum pain relief? So by executing that document, you're kind of taking the burden off of your loved ones to make decisions as to what you would want in terms of prolonging your life if you were in an irreversible state. So we covered healthcare proxy and we covered living will. The third document is a power of attorney. Everybody has to have a power of attorney document. In New York State, we have two. We have what's called the New York Statutory short form, which is a durable power of attorney, which you appoint somebody to be your immediate agent. It does not depend on whether or not you're incapacitated. So I always say to my clients, if you're going to appoint someone as your agent, it's got to be somebody you really trust because they have immediate authority. They don't have to prove that you don't have capacity. This keeps things smooth, very fluid. So if there is a sudden episode where you cannot get to the bank or you cannot renew your lease for a rental apartment because you're sick or whatever, your agent steps into your shoes, does not have to prove that there's an episode of disability, and can make decisions on your behalf. The companion form to a New York durable power of attorney is what's called a gifts rider. And that is a more complicated form. It must be executed under the supervision of an attorney, where a durable power of attorney does not need to be supervised by an attorney. The reason why is that the gifts rider is giving very broad powers to your agent. Under a durable power of attorney, your agent has a fiduciary duty to manage your money, to make decisions on your behalf. They do not have the authority to use your assets for their personal benefit. where the companion form, the gifts rider, extends the authority. It actually allows your agent to do gifting. Now, why does New York allow this? It does it really in the context of two scenarios. One, you could have a taxable estate, and maybe it is important to do some gifting, maybe to a charity or to a loved one, to reduce the burden of estate tax liability when you pass. So you're giving your agent the authority to do some tax planning that may be needed, depending on the size of your estate and depending on the estate tax laws at the time of passing. The second reason is very helpful in New York is because many people need to apply for long-term care assistance through our Medicaid program. And it's a very complicated landscape to negotiate. When you have a gift rider in place, it really helps the elder law attorney that may be assisting your family to do some planning in terms of reducing how much money would be at risk to pay for your care before you would be eligible for Medicaid. The fourth document is a HIPAA form, and that allows the release of medical information and medical records to your agent. So you're going to identify in that HIPAA form who would have the authority so that a doctor, a hospital, the medical records department in a hospital would have the authority to release information to your agent. This is really important now in the crisis that we've seen due to the coronavirus. Many people could not get information from loved ones, especially if they weren't here in New York, but even if they were in New York, nobody could get to visit anybody in the hospital. So if a hospital does not have a release of information, a HIPAA form in place, they are subject to violations for giving out information without your consent. So by you having this form signed in advance, it's really going to protect communication in the time of crisis to your loved ones and to your agents. And then the fifth document really comes under two categories. Everybody needs to have either a will or a trust. Now, there are many different types of trust, and I'm really focusing here on a revocable living trust. A will is subject to probate, and it has nothing to do with protecting your assets during your lifetime. It only becomes an active document upon your passing. It has to be presented to the court, surrogate's court here in New York or whatever borough you're in, and the court has to determine that it's a valid will. It's been executed under statutory law. It has to have two witnesses. Once you get through the hoops of probating, the court will give your executor, which is called letters testamentary. It's kind of like their power to marshal your assets, to go out into the world and to say, I have the authority to go to Chase Bank, Wells Fargo, sell your property, get into a safe deposit box, whatever the course of action that is needed to gather your assets. Remember, before having this letters testamentary, your estate is frozen. This is a financial burden for families because the assets are frozen. Where's the money coming to pay for a funeral? Where's the money coming from to pay an outstanding mortgage, rent, utilities? So it really brought to light, one, the importance of having proper documents, and also the distinction between if you have a will and if you have a revocable trust. When you have a revocable trust, you bypass probate. You don't need probate, okay? Because your assets, if you have followed the instructions of the attorney that you worked with, attorney would have advised you that you need to retitle your assets to your trust. So there's no reason to go through probate. You don't have to follow the rules and regulations. You don't have to worry if the court is closed, because your assets have already been retitled to whatever you have named your trust. So it keeps things very fluid. So if somebody passes, the next day, their successor trustee could put a sign up in front of their house and sell the home. There's no need to get letters testamentary from the court. So it's a tremendous planning vehicle for organization and for making sure that you're not under the microscope of the court. It's private, it's organized. Nobody needs to know the value of your estate. When you probate a will, it's a public document. Anybody can really see it. Also, the advantage of the trust is that the trust does act as a backup vehicle for you during your lifetime in the event of incapacity. Because once the assets that you own, whether it's a house or a brokerage account or a savings account, has been retitled to your trust, if you become incapacitated, you don't have to worry about having to have someone petition for guardianship on your behalf so that they have the authority to make decisions about your assets or to gain control of your assets, because the trust already has title. So it keeps things very fluid, again, during a period of incapacity. I'd like to just sum up by saying that an estate is everything that you own. It's your life insurance, it's your brokerage accounts, it's your 403Bs, it's your IRA, it's annuities, it's jewelry, it's artwork, it's your car, it's your boat, and it's property that you have all over the United States, and also any international property. It's calculated, and at the end, we are really trying to figure out not only the distribution, but whether or not you have a taxable estate. I hope that you found this helpful and look forward to speaking to you again in our next video. Thank you.